Welcome to Business Law 1, Unit 6. We'll be covering the topic of agency today. All right, the agency relationship. Sometimes you know it from a general sense of employer-employee, but there's more to it than that. The root of the agency relationship is a fiduciary relationship. Perhaps a new word, fiduciary. Let me read the definition for you. Results from the manifestation of consent by one person to another that the other shall act in their behalf and subject to their control with the consent of the other. So, in an agency relationship, there are two parties. There is the principal and the agent. The agent acts on behalf of the principal in this fiduciary relationship. The principal is sometimes known as the employer, but it may not always be the employer. All right? So, for example, you might think of like a factory worker who works on behalf of A.O. Smith Corporation. All right? A.O. Smith is the principal, the factory worker is the agent. The A.O. Smith controls how the employee, the agent, does their work. As a result of that, they are also liable for what the agent does while in the course and scope of the employment relationship. So, the two parties involved in an agency relationship, principal and agent. Why is this important? Well, it's important because the principal normally is liable for the torts of their agent / employee. They also have government obligations, they have duties to one another, and they could be liable, the principal could also be liable for the contract liabilities of the agent. And we're going to discuss more of this in detail. Today, I'm going to primarily talk about tort liability, the principal's tort liability with regards to the agent. And then in class, I'll review it again, and then we'll go into more detail on the contract liability of the agent / employee on behalf of the principal / employer. All right, let's begin. First thing I'd like to point out to is go to item number 2, tort liability, with regards to an employer versus employee. All right, in common law, the employee was known as a servant. They were a type of agent where the employee's physical conduct was controlled by the employer, back then the master. All right. The employer, once again, is considered the principal and generally is liable for the employee's torts. This is the big general rule. The principal is liable for the employee's torts if committed within the course and scope of the employment relationship. Now, you might be asking, well, what's a tort? A tort is simply defined as any wrong or injury caused by one party against another party. All right? So, if I accidentally hit you with my car, I've committed a tort, and I'm responsible for the damage to your car. Now, I could do that accidentally, or I could maybe know who you are and I run my car into you on purpose. That'd be an intentional tort. An accidental tort is called a negligent tort. All right? So, let's work through the outline. I'm still on item number 2, tort liability. Well, this is known, this liability that the principal has on what the agent does, this is known as the doctrine of respondeat superior. All right, let's read through the examples together. You may see these again on an exam. For example, Sue is an employee of Mike. One day while delivering inventory for Mike, she negligently hits a third party with a delivery truck. Although Sue is liable because she committed the tort, Mike is also liable. So I'm talking to future employers of America, small business owners, maybe large corporate owners. That should raise your eyebrows. You've hired employees, maybe you got 100 employees, and one of them accidentally hits another vehicle. Well, you're responsible for that if it's in the course and scope of employment while they're working for you. All right, and so the next topic is course and scope of employment. This is broadly defined, which means it's very loose. It's broad to fold in the liability of the principal / employer. Let's go through the example. Mike, the employer, gives Sue $30 and asks her to go buy donuts for the employees who are working overtime. Now that's not Sue's normal job, but that's what Mike, the employer, asked her to do. Okay? Sue takes their own car and injures a third party through their own negligence. The employer, Mike, is also liable for the negligent tort. Even though that's not Sue's normal job, it was within the course and scope of employment because Mike, her employer, asked her to go get the donuts. And once again, that should raise your eyebrows. You're liable for the torts of your employee agents. All right. Item number 3, the employee need not be following instructions of the employer. All right. The general rule still applies even if the employee violated the employer's instructions and negligently committed a tort. All right. Let's read the example. Paul works for Q delivering widgets. One rule that Q has is that all employees must look behind the truck before backing out after all deliveries. Paul violated this rule and injures R. Q is still liable even though it would have taken steps to prevent this type of accident. So, even if the employer has a handbook that tells the employee what exactly to do, but the employee is negligent and accidentally causes harm, the employer is still liable. Item number 4, contributory negligence. What if the third party's negligence is generally a defense? If the third party contributes to their own harm, it's generally a defense for both the agent and the principal. All right, you'll see a couple questions regarding that. Well, the next big item on the outline that's important to note is the distinction between an employer and an independent contractor. All right? I think we know what an employee is. What would be an example of an independent contractor? Well, it could be when you hire like a real estate agent. They're acting independently. You don't control their behavior, so they would be considered an independent contractor. In construction business, I've had employees that I control their behavior. I supply the tools. I tell them how to do the work, when to do the work, how much I'm going to pay them, and that sort of thing, per hour, that sort of thing. So those would be considered employees, and I'd be responsible for their torts. I have also hired or contracted with subcontractors who have done the plumbing, and we just agree up front how much I'm going to pay them to do that particular contract. I don't control how they do it. I don't control their time. I don't pay their individual plumbing employees. I don't subtract. I don't pay their employment insurance or their health insurance, or I don't keep any money from to then forward to the IRS. I don't control how they do their work. I just know that the work needs to be done, completed and done to the industry standard, and then I pay the contract. They are independent contractors. And the big deal here is I'm not liable for the torts that the independent contractor employees or workers commit while on my work site. So I might hire a plumber, an independent contractor, and maybe they cause a leaky pipe that causes more damage. I'm not liable for that. The independent contractor's liable. Or maybe they have one of their employees who's a plumber who drops a hammer on another employee's head accidentally. I'm not liable for that. The independent contractor is liable. That's the big deal. Okay? So we go over what's the criteria to determine whether an individual is an employee or an independent contractor. That's the big ta-da here, okay? So we look at these criteria. Number one, how much direction and control the employer exercises over the details of the person's work. Okay, that is actually the most important aspect. That's what the IRS uses as the key distinction between it being my employee or an independent contractor. Whether the person's engaged in an occupation of business, a distinct business. So I hire a plumber, and this plumber has its own work site, its own office space, and they have multiple clients like me and like other work locations. They supply their own tools. I didn't supply any tools to them. What degree of skill is required? A plumber takes quite a bit of skill and knowledge on how to do it correctly. How long have they worked for me? Or have they really worked for this independent this plumbing company, and they work for multiple work sites, all right? And then the method of payment. I don't pay the individual workers or individual plumbers. I pay the company that has employed these independent, who employs these plumbers as part of their business, all right? And I don't keep any of the unemployment insurance or health insurance or IRS withholdings from their pay. All right? So as you review that case, you'll be able to navigate case 23.2. All right. The rest of the remainder of this presentation is really just a mop-up. Item 3, employer government compliance obligations. Just read through that and know that these are all the withholdings that a normal employer-employee withhold from a paycheck versus an independent contractor that doesn't withhold any of those. And then finally, items 4 and items 4, agent's duty to the principal, and then the principal's duty to the agent. Please read through those, know those. There'll be a couple questions on each of those duties to one another. All right, I hope that helps. Next time we meet, we'll go over the remainder of the agency law. We'll review this once again, and then we'll focus mostly on contract liability of the principal with regards to what the agent does. Thank you. See you next time. Bye.